application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We do the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my lord, if that applications were to succeed, then it would effectively mean, as my learned colleague Mr. Ngoya has indicated, that then the issue of recusal of your lordship becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners allege were committed by the Deputy Chief Justice King, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told instructions. Well, when we came here, we thought that while we were proceeding and actions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When you were given 1 hour, we told them, oh, stop on the issues of recusal, now we are dealing with another thing. So, my lord, we cannot be able to argue, if it is today, we cannot be able to argue, as expected by our client, on the question of recusal. And there is no similarity of issues. Therefore, my lord, I urge you that let us adopt fair procedure. This fair procedure has there a
specific application for recusal?
There are 2 applications.
Where are they?
At least I know, Trevor will mention one. Yeah. We are actually bringing them, even one of them in number 015 is an application dated, I believe, yesterday, 21st of October. There is another one.
Okay. These are the directions we are looking. We'll deal with the application before us. The application for empanelment of this bench
Can I have application of next year?
And perhaps my lord, before you give the directions, with my friend Immortal, she's informing me that she was not aware of the elections in the morning, that applications be filed and we come back before you, and now her petition has been integrated in the consolidated petition, that is petition number E013. Therefore, she's not been able to file an application either for refusal or for challenging the empanelment. She was just requesting if she can be served with those applications and the responses, and she be given time, 1 hour just like the others, to file her similar application in she wishes. Because now she's participating in the proceedings. Council, listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. We are dealing with the issue of empanelment. And then after that, we'll look at ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay, but let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation, Judge Mureba will give the final issue directions on time.
This is how we proceed. The applicant the applicants will have 20 minutes to argue their application. Any party in support of that application will have 5 minutes to support that application. And the respondents will have 7 minutes each to respond to the application, as well as any other party which will want to.
It's easy. New Techno Phantom V series. Techno, stop at nothing.
Do you still want to come through for your family and loved ones? Like, what are the sacrifices you've made that you wouldn't have had to make if you didn't have to take care of your family?
By now, I could be owning my own business.
I want to talk about black tax. Does it affect you?
You cannot maintain a girlfriend or a lover when you're really taking care of your siblings. It comes with a lot of financial muscle.
Remember, we can always be there to support our family and loved ones. But with the right financial solutions, we can do it in such a way that it doesn't prevent you from achieving your personal financial goals. Our experts are just a phone call away if you need more information.
Dr. Kamuna, we please, you are not audible.
Oh, I'm sorry, I'll speak now.
Yes, speak.
I received instructions yesterday from the project here that I come and make an application that Kituoje Syria would like to be joined this week. We all know Kituoje Syria. We can't pretend that we don't know Kituoje Syria. And we know the role Kituoje Syria has played in advancing the jurisprudence of the Christianity and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder at the bar and one who has seen for a number of things which I may not be able to say if I'm representing the position.
That is okay. We have done that.
Thank you very much. May I then comment on one small thing? My Lord, the country is not crisis. There's a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so, with tremendous respect, this is not a matter where you should be allocating some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process. To the 50 million of Kenyans. A number of them are glued now to radios and TVs, trying to hear what is being said in this court. And for this honorable court to come and say that my ever friend, Mr. Mwite, will only have 10 minutes, will have no 5 minutes.
Mr. Mwite asked for 10 minutes and we allowed him to have 10 minutes.
He said so because he was under coercion.
What? I think Dr. Hamuna.
I have taken the trouble to read this constitution of Kenya. I have taken the trouble to read constitutions of other countries. In fact, the way things stand at the moment, the constitution law is evolving in such a manner that it's no longer confined only to Kenya. We can have a concept of international constitutional law. And if you read that law, including the American law, which I've taken the trouble to read, and which I've had access to it for many years.
Dr. Kamuna, we made proposals and we gave directions. Apparently, you are not satisfied. What is your version? What would you want us? You want to give everybody how much time?
My Lord, forget about the concept of time. Forget, where are we heading for? What are we heading for?
So, yeah.
Yeah, we want the country to wake up and to revive and to give the life to the country. The country is Kenya, if you don't know what I'm talking about. Your Honor, let the lawyers say what they want to say. This should be part of the healing process of the whole country.
Dr. Sakamino, I ask you.
Yes.
We have given directions on time allocation.
Your hands are not tied with respect.
Okay, tell us, just tell us, in your view, how much time do you want us to allocate parties? What
I'm saying to the tremendous respect, my Lord, we talk about time in civil matters and so. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is touching the whole nation. It has paralyzed the nation.
We have heard you, Dr. Kamino.
Let Paul Rita be given as much time as he wants. Let the professor be given as much time as he wants. Let the honorable attorney general be given as much time as he wants. That is the healing process. And from this court, we shall all march forward with confidence. If I may quote Mutaje Mokinata, before and buried the Matako New. Let us forget about corporate time. Where are we going?
My Lord,
where are we going with
please Dr. Kamino.
With respect, will you sit down? Kamino is talking. Will you sit down? I am talking.
Under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I, as senior counsel.
I will not sit down. We're not practicing lawyers. We're doing breastfeeding.
That is also. So my Lord,
that of ironic. My Lord, what I'm
Dr.
saying,
Kabila, finish what you're saying.
what
so
I'm
that-
saying to you, my Lord, we need a healing process, and this court is going to provide that healing process. Let the lawyers say what they want to say. What are we hurrying for? Let us not have some people calling themselves professor or senior counsel, titles that don't mean anything at all when it comes to this.
I think they mean something, Dr. Kabila. They do mean something.
Something means something when it is you and you approve it. Yeah. My Lord, all that I'm saying to you, let people talk. Let people address you. Where are we going?
People will talk.
When the country is burning.
Dr. Kabila, you have made your point.
Yes, thank you very much.
You have made your point.
I have made the point. Yes.
Professor.
We have a Deputy Chief Justice who has been removed irregularly. Let us be given time to be able to address it.
My Lord, I think those of us who are representing substantive respondents, we all agreed that you have given orders that we will comply with, including my learned senior, PK Moite, who I believe you have added some more time and he's happy with that. Maybe it would help if we informed Dr. Kaminwa that it is not the whole matter that is being heard in 10 minutes. It's a very small slice of an application on impound. That's all I wanted to clarify.
So, Dr. Kabila, I've heard what you say. We'll stick to the time allocations, but in the event that one party needs more time, they will tell us.
Well, when we come to substantive matters, let people
I
say
agree
what they want
with you.
to say.
I agree with
Yeah,
you. Thank you.
where are we heading to?
Thank you.
Yes. Thank you.
In view of that time allocation, and I thank senior counsel, the senior most going by the Kenya law reports before you. May I
By the way,
beseech your
mention my
lordship,
name. Mention my
Dr.
name.
Camino.
Thank you.
My Lord, even the report of the East Africa Law Committee confirms that. My Lord, the point I need to make, and I beseech you, because of the serious time that we had to prepare this application, I could only prepare for certain aspects of this application. My colleagues, Professor Gada, and my colleagues, Ndego and Jiro, within the 20 minutes that you have allocated, I will say my piece. It is insufficient, but I'll try. Please give Ms. Professor Gada and Mr. Ndego and Jiro 10 minutes each, and at the end, when we hear what the respondents are saying, you kindly give me a hint, indicate 20 minutes to do anything. That will enable us to be able to proceed without anybody feeling we want to be here forever. We don't actually want to be here forever. We want to deal with the business of the day. So that, that does not change any time allocations by more than 30 minutes. So I urge you not
So who's starting?
I'm starting. Okay. Yes. So that I do 20 or gather 10, 20, because he has to deal with some authorities. I didn't get enough time. I missed 10. Then I'll do the rejoinder. But the application that is before you is dated today. It is supported by the affidavit sworn by. It is supported by the affidavit sworn by Honorable David Munyi Madenge. And for the record, all lawyers from Matiba, Ogada, Ndegwa, and myself, the record indicates we act for everybody without drawing any distinctions, because I believe there will be no time for that. So we act for all the respondents, all the petitioners, for purposes of E015. My Lord, before going on to argue this application, there is a small point that I wish to make regarding the issue of why are we having a situation where to everybody watching we seem to be following an unusual path. My Lord, there is one substantive issue of procedure that we need to point out. The petitioners are before you on account principally of the violations of the Bill of Rights. The petitioners are also here on account of the relevant provisions of impeachment. The petitioners are before you, my lords, on account of the fact that the business that the framers of the Constitution ordered, one, for appointment of a nominee to take place within 14 days, and for Parliament to do it within 60 days, somehow happened within 4 hours. My Lord, those are the principal reasons why we are here. And what is the immediate context? The immediate context, my lords, and why we are here is that when petitions are filed, the duty of this court under Articles 19 all the way to 25 is to ensure that it decides whether or not the violations as alleged by the petitioners has taken place. My Lord, the way in which the law, and this is express positive law, requires that to be done is by way of a judgment. By way of a judgment is the only way that the people of Kenya would be satisfied. Have these rights been violated or not? In order to ensure that that judgment, which is the express constitutional mandate, is given in circumstances that are not academic, Article 23 of the Constitution provides that conservatory orders may be given. When this matter went before your brother judges, probably a sister also, in their wisdom, they directed this matter as such enormity that we need to preserve the subject matter. That subject matter, my Lord, the preservation of it would be to ensure the relevant office remains vacant until this case, through a judgment, pronounces itself. But my Lord, why are we here and why is there a heated discussion? We are here and we are having a heated discussion because what is the clear intent of the Constitution is being circumvented, so that to ensure that the subject matter is not preserved. My Lord, this would be akin to a situation in which somebody comes and says, I am being evicted and my things are being removed. A court says, stop the eviction process up to where it has occurred. Then the respondent comes and says, no, leave those orders so that I can carry those things that it is alleged I was unlawfully taking. So that, my Lord, in the face of the fact that what conservatory orders are supposed to serve, I beseech you, and I believe the entire country would expect that there has to be preservation of the subject matter of the application. So that, my Lord, now, that being the context, it is absolutely important that we do not lose sight of the moment. It is heated, one, because there was a sitting on Saturday. Before application responses could be made, we found ourselves here. We were supposed to come here on Thursday. We are here on Tuesday. So that, my Lord, and there are a lot of matters that directions must be given. So that, my Lord, that context would be absolutely important, because when all is said and done, the critical issue before this court is a right under Article 25, the right to fair hearing and human dignity. Right to fair hearing and human dignity cannot be violated even during an emergency. My Lord, that being the background, I ask you, and we shall be asking you, because that is the context where all these things are happening, that you ensure that whether heaven falls, the High Court must stand up, if for nothing else, for the right to preserve the subject matter until this High Court pronounces itself through a judgment. Because that is express law. Having said that, my Lord, I come to the prayers. The prayers are like this, and we have already indicated. There are about 6 substantive prayers. The linchpin of these substantive prayers, my Lord, is the fact that the Deputy Chief Justice under Article 165 does not have the power to appoint or assign, as the words used by the Constitution, members of a certain court to hear the matter. My Lord, Article 165(4) is very clear. Where the Constitution says the President and Article 149 can nominate Kindiki, there is no argument that is made that a minister or somebody else can be made. We expect that there can be no feasible argument where the Constitution has expressly said that the Chief Justice shall do something. The Chief Justice in this case did not empanel this bench. My Lord, we are urging this honorable court to make a finding that unless the Constitution is interpreted or amended to give the Chief Justice, the Deputy Chief Justice, the power to empanel a bench by express reading of the Constitution, she cannot be able to do that. Issue number 2, my lords, is that it is not for nothing that it is one of the biggest occasions that the senior most judicial officer is the one that the people of Kenya, judicial power in the first place vests in the people. Judicial power by express words of the Constitution or to do this appointment and work under Article 165 was vested on the Chief Justice. It is not by accident. It is by the express intention. So that, my Lord, on the face of it, when a state officer who is not directly mandated to do something ends up doing it under public law judicial review, it is done every day. You did not have the power under statute or the Constitution to do that. There are so many cases, starting with Madhu versus Republic. I think it was sometime in 1974, where somebody at City Council did something where the law did not allow that person to do that. So that, my Lord, all these cases we are aware of. So that, my Lord, as far as Article 165 is concerned, we submit that that is not possible. But, my Lord, this argument is developed a little bit further by the petitioners' applicants. Because the petitioners' applicants are saying that the Deputy Chief Justice, having usurped the powers of the Chief Justice, she proceeded to do 2 things. 1, to sit at night to appoint a bench, and to authorize that bench that sat on Saturday to conduct their business on Saturday. But those are irregular, because as we are saying, when this is not a matter of public emergency. Of course, it was a matter of public emergency before the National Assembly and before the Senate. But because of the timelines we've given you, my lords, it is not a matter of public emergency. But having found herself in that situation, she decided to treat this matter as one of public emergency. Then, my lord, she directs come and sit on Saturday. We have set out in our applications and in our affidavit. There must be certain circumstances under our laws, the High Court Administration and Organization Act, that can justify for any bench to sit outside on Saturday and Sunday. There must be express reasons. Those express reasons, as we sit here, agreed. We still do not know them. And if we do not know them, every Kenyan who would be aggrieved by a decision made in these circumstances would have every reason to be concerned that from the word go, there was a conspiracy to commit injustice. My Lord, all of you have been honorable members of the High Court. There cannot be, where there is no public emergency, for occasions to arise that for the first time you would effectively be accused. You engaged yourself in a conspiracy to to undermine the constitution, and to defeat it in a manner that would amount to treason. So that, my lord, the point that we make is that in the absence of a public emergency, what has so far happened is not only just unconstitutional, but something that would amount to violation of the constitution, and something that would amount to violations of the penal code, as far as the issue of observing justice is concerned. My lord, for argument's sake, we proceed to make that argument. Let's assume that there was an emergency. We submit there was none, but let's assume there was one. If there was an emergency, then it was incumbent upon the Chief Justice to read, and they were in the newspaper and in the news, all these cases that honorable judges of the High Court from various stations had recommended for a bench to be appointed to hear them, to consider them, and place them for hearing on Saturday, and to fast track that hearing. But, my lord, what is it that happened? My lord, what actually happened is that you have a situation whereby the respondents, who are basically agents of the government of Kenya and its various appendages, have gotten their applications to be satisfied and for a bench to be specially convened to sit, because from the standpoint of the petitioner, to set aside the conservatory order in order, as the petitioners contend, the violations of the constitution may be completed. My lord, justice in this case, if it means anything, it must mean a very simple issue. The multiple violations of the constitutions that are already ingrained and embodied in the various applications, we cannot allow them to be completed, because this is what it's all about. This is what the decisions of the Chief Justice was all about, to complete the serious violations of the Kenyan constitutions. By your oath of office, your lordships are committed to stop a respondent and a government and its appendages that act in this manner. My lord, what does it amount in law for the Chief Justice to say you have about 15 or 20 cases, as I hear from my learned colleagues who have been in this matter longer than me? I'm here today for this matter, and I'm here because there is a constitution in Kenya. My lord, that being the case, there has to be satisfaction. If the Chief Justice, and she's a party in this application, cannot be able to justify why did you choose to address the grievances of the Attorney General and the government of Kenya and leave the petitioners. The first right of hearing under our constitution, I deal with Mutunga rules every day, is that the petitioner will have their rights to be heard, to prosecute their case. That is what the Bill of Rights means. The respondent, even under Mutunga rules, will respond and answer the allegations that have been made. But, my lord, where the Deputy Chief Justice chooses to fast track the grievances of the alleged violator, common sense has to be affected. My lord, the conscience of this court must be bothered. Such conduct, in the normal sense of things, we went through the removal of judges during those days. There was just minor infractions of the right to be heard, and judges were shown the door home. But, my lord, here it is a systematic decision consciously made that would have very harmful effect for the jurisprudence of our country and for the meaning of our constitution. So that, my lord, so that my learned friends can be able to speak for themselves, we are alleging that as long as the bench has been appointed by the Chief Justice, who has declined to follow the fair process for purposes of appointment of the various judges to see, there cannot be a valid appointment. Not because I and my colleagues here would have anything on a good day before any of you, your lordship. We have done very many matters. You have courageously stand up for the constitutions in various matters, but, my lord, unhappily, we have to be the ones saying that it would appear to a section half of this country, if not 3/4, that you have been enlisted in service of the violations of the Constitution. My Lord, that may not have happened, but that is the only way reasonable people would be able to interpret all this, particularly against the background that even the Gen Z were abducted. The substantive Chief Justice did not empanel a single bench to sit on Saturday or on Sunday. That is why this, but the context in which this matter must be viewed. My Lord, there are certain authorities, my learned colleagues will go through them, but I need to mention at least two things. My Lord, of course, the arguments would be made. I think there was some time back, probably in the Okiya Omtata case, my learned colleague will clarify, where the Deputy Chief Justice, the same Deputy Chief Justice, made an appointment. There was no substantive Chief Justice at that time. There was a decision that was saying this is administrative. That decision is not binding. But my Lord, more importantly, now that this issue is arising directly, this court must retire, make a very reasoned decisions to settle this issue. Whether in every other case in which the Constitution or statute says so and so will do this, if that so and so does not do it without failure, the High Courts and the Court of Appeal have always held there was no jurisdiction. An order of certiorari have always issued. It shouldn't be different in this particular matter because the power belongs to the Chief Justice. Now, the second issue is a decisions, I believe, one of you was involved, and I believe it is a case of Okoichi Omtata versus JSC, and the decision in that decision was that at paragraph 29 to 38, basically it says that where there is a substantive Chief Justice who is a state officer, she does not cease to be a Chief Justice in this era of technology. And accordingly, the Chief Justice, the CJ, does not have authority under the constitutions to assign roles assigned to that office. So that, my Lord, in this case, even assuming that in writing the Chief Justice had assigned this role to the deputy, and that has not been alleged, it would still not be good enough, because wherever that the good Chief Justice might be, this is something that she could have done as expected her. And the people of Kenya obviously would be interested because of the nature of this matter. Why would the Chief Justice abdicate to do her job and let her deputy to do her job in a manner that aggrieves the petitioners? That is an important question, because it is the job of the Chief Justice. There is a huge mandate that is given by the Chief Justice. Do your job with the entire authority that your office carries. So it cannot just be that it is for the Deputy Chief Justice who has usurped. It is also abdication. What would be the basis for abdication? The Chief Justice not to do their job. The other case of, just 1 minute, 1 second. The other case of, I think my learned colleagues, so that it can be fast, I don't want people to knock me. My learned friend can, my learned friend can do her, let him do his 10 minutes, then he can do his 10 minutes.
Thank you. Thank you very kindly, my lords, my lady. I'll only highlight a few issues which are legal. I'll move from Article 1 of the Constitution, your lordships. That Article 1 has created organs of government. Among them is the organ of the judiciary. And it has clearly provided, your lordship, that the people of Kenya, in the exercise of their sovereignty, they have delegated their powers to those organs. In this case, the power under Article 165, Clause 4, is exclusively delegated to the Chief Justice. Your lordship, in administrative law, we all write that a person who enjoys delegated powers cannot further delegate those particular powers. In this case, in this circumstance, your lordship, it is not known to the petitioners under what circumstances the Chief Justice may have delegated these powers to the Deputy Chief Justice. It is our humble submission, Your Lordship, that the powers and the functions under Article 165, Clause 4 are not capable of being delegated. Further to that, Your Lordship, you seek leave under Article 159 of the Constitution, which provides that, Your Lordship, that judicial power is derived from the people and shall be exercised by the courts and tribunals established by this Constitution for and on behalf of the people. That article again clearly indicates that this power under Article 165 Clause 4 is not capable of being delegated. How about, Your Lordship, in the Constitution? Your Lordship, I invite you to look at Article 160 or 260 of the Constitution. It provides if a function has been created to be executed by that particular organ, it is only that organ that is capable of executing that particular function. And for the question of further delegating that particular function cannot arise. The Deputy Chief Justice had the constitutional mandate to appoint this bench to adjudicate over these particular files. Your Lordship, we have put up a case that the Deputy Chief Justice has not only violated the Constitution, but also violated the rights of the petitioners to be heard under Article 50 of the Constitution. When they moved to appoint a bench of this, the bench, and failed to notify the parties herein as evidenced by the counsel appearing for the petitioner in petition number 14, it tells Your Lordship that the expediency for which it was done was so as to meet the objective of setting aside the orders that were granted by your brother Justice Mongo and your brother Justice Mwita. Your Lordship, when you retire to make a ruling of our application, it is important that you pay serious attention to paragraph 12 of our affidavit, paragraph 21 again of the affidavit, paragraph 22 again, and also paragraph 27. And then you might want to ask yourself, under section 10 of the High Court Organizations, High Court Administration Organization Act, how, under what circumstances the Chief Justice, the Deputy Chief Justice, authorize you to sit on a Saturday? Under what circumstances did the Chief Justice herself, Deputy Chief Justice herself, sit at night, in the wee hours of the night, ungodly hours, and constituted this bench? Your Lordship, is our humble submissions that Article 10 has only arrogated that function again exclusively to the Chief Justice, and that the Deputy Chief Justice has no power under Section 10 of the High Court Organization and Administration Act to order you or to authorize you to sit on an odd day like that or the Saturday. Your Lordship, permit me to draw your attention again to the case of Okia Omtata. When you retire and the judgment will be highlighted by my learned friend, it is of importance, Your Lordship, that you look at paragraph 192 of that judgment. It has given the circumstances under which the Deputy Chief Justice can act in the absence of the Chief Justice. One is if the Chief Justice is indisposed, if he resigns, if he is dead, or if he is holded out of office. The question of leave, to which we are submitting without knowledge whether that is the circumstance that led to the allocation of powers by the Chief Justice, is not one of the grounds or reasons that the Chief Justice can exercise, the Deputy Chief Justice can exercise the exclusive powers meant for the Chief Justice. Finally, Your Lordship, all these averments contained in our affidavit have not been controverted by the respondents through a replying affidavit. They have only filed the grounds of opposition, to which they shall bring to your attention the case of Container, which has been distinguished by the case of Okia Omtata. The grounds contained in our affidavit, Your Lordship, are uncontroverted and they must be admitted as such. I beg to rest my case.
May we request council to give us specific reference to Okio Matata has been mentioned by two council. He's probably the most prolific litigator in the history of Kenya. So we don't know which of his many cases are you referring to.
I will certainly be addressing my senior at the bar, senior at the academy, Professor Gideon Mugai. It is a pleasure being with him in court. A man or woman who plants a tree, not knowing fully well that they will not sit in its shade, knows the meaning of life. You sit today in such an epochal moment that what you do here has significant ramifications for the Republic of Kenya. It is for you as a court to rise to the occasion. This court has defined the Constitution as a transformative constitution. And this was done by this very court, differently seated in the BBI case, David D. and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution of a transformative character. And this transformative character of the Constitution induces large-scale social change, including the character and conduct of politics. That the Constitution bears an internal theory of interpretation. Starting point for discerning that internal theory is Article 259 of the Constitution. That formalistic approaches to constitutional interpretation are not favored. And lastly, that the Constitution has provided for its own theory to protect its values, objects, and purposes. That is what is before you as a court today, that you are supposed to maintain that innate character of this Constitution as a transformative charter. The other side has filed grounds of opposition, and in their grounds of opposition, they raise a case, Lona Conchela and others versus the Chief Justice. That was the grounds of opposition by the Attorney General. And in that case, this High Court said that the power to appoint a bench is administrative, and that power can be performed by the Deputy Chief Justice in limited, constricted circumstances, so that the normative holder, the Chief Justice, performs it, but the Deputy Chief Justice has to perform it in certain limited circumstances. Those limited circumstances have to be demonstrable. That is Conchela. Your Lordship Justice Murima, sitting in Okoiti versus JSC and another petition, E408 2021 EKLR, I believe that is what Professor Gideon Mugai was asking about. Paragraph 29 to 38. Justice Murima finds that the authority under Article 165(4) is a constitutional authority, so that authority cannot be delegated by the Chief Justice, because the Chief Justice does not cease to be a state officer, even on leave. We have another authority here, Petition 31 of 2013, Kenya Medical Research Institute versus the Attorney General. This is found at 2014 EKLR at paragraph 37. Kenya Medical Research Institute versus the Attorney General and three others, 2014 EKLR. This case at paragraph 37 says this, that the Chief Justice under Article 165(4), the authority to empanel a bench, performs a constitutional mandate. And this is not an administrative function, as was in the old Constitution. Where do we go? I'll invite the court to look at the express wordings of Article 259(3)(a) that expressly decrees that authority granted to a specific office must be performed by that specific officer. That is Article 259(3)(a). I'll want this court to consider the decision of the Court of Appeal, and this, the other side can take judicial notice of, the court can take judicial notice of the case of Karisa Chengo, whereby the office of judge and the person of judge are synonymous. Such that the Chief Justice, the person, and the office of Chief Justice are synonymous. And therefore, we cannot separate and delink the holder and the person. And therefore, if the Chief Justice were to delegate any responsibility to the Deputy Chief Justice, assuming that was possible, then the Deputy Chief Justice has to take an oath by virtue of Article 74 of the Constitution. There has to be instruments prepared authorizing the DCJ to act as Chief Justice, and for what purposes? Ladies and gentlemen, Honorable Court, the Greek tale of Ulysses, the coxswain who was asked to block his ears using wax and to avoid the temptation of alluring music, that story echoes well for you today. It's politics, there's a lot of heat and rancor, but for you, as the court, an apex court under the Constitution, yours is to uphold and defend this Constitution as required at Article 3. That's the sole mandate of this court. Thank you.
My lords, my ladies, I stand here to argue the supporting arguments for the first substantive petitioner, His Excellency, the Deputy President. And in the 10 minutes given to us, I will take 7 minutes and leave 3 minutes to my learned senior colleague, Senior Counsel Paul Mwite, who is his to take the lead in arguing this point. Allow me to begin by juxtaposing 3 constitutional provisions, then pose the challenge that I will ask my lords to retire with for purposes of your consideration. The first is Article 141, Clause 1 of the Constitution. Article 141, Clause 1 of the Constitution provides, and I read, that the swearing in of the President-elect shall be in public before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice. It's very clear. Says who must do and what will happen in the hands of that person. Article 148, Clause 4 of the Constitution provides, and I quote, the swearing in of the Deputy President-elect shall be before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice, and in fact. Another very clear stipulation of our Constitution of what the Chief Justice can do and what will happen in the absence of the Chief Justice. Then we go to Article 165, Clause 4. I want to emphasize one thing, my lord, my lady. You notice that Article 141, Clause 4, Article 148, Clause 4 come before Article 165, Clause 4. The makers of the Constitution were aware of what would happen in the absence of the Chief Justice while drafting Article 141, Clause 1, Article 148, Clause 4. Let us see what they said at Article 165, Clause 4. They said, and I quote, that any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an even number of judges being not less than 3 assigned by the Chief Justice, full stop. I'm always encouraged by an article my mentor, Professor Rigathi Gachagua, wrote many years ago called Political Jurisprudence or Neutral Principles. Another look at the problem of constitutional interpretation. And Professor Rigathi Gachagua makes an important argument that decisions of constitutional courts must be formulable in such a manner that they would apply coherently to all subsequent cases of similar facts. I'll not read these names in full, but you now know that if we approach this court and read for it Lena Conchella, the decision already alluded to, it will appear that this court's position is this power by the Chief Justice is administrative. If we approach this court and read the case of Kemri and the case of Montata, both of which have been referred to by my learned colleague Mr. Gada, you'll notice that the power under Article 165 is not administrative. The court says so, and my Lord Judge Murima, you contribute that jurisprudence. It is a constitutional imperative. I think my teacher, Professor Rigathi Gachagua, would frown at that in jurisprudence as being political jurisprudence, because then we cannot answer first-year law student coherently. Is it administrative or is it not? We will find it difficult to answer it. Fortunately for you, as judges sitting here, you are not bound by those previous decisions, and you must come to the correct interpretation of the law in a manner that would address similar cases in the future coherently and without subjecting the judiciary to possible embarrassment. So then you will have to go and read what the two cases say, Kemri and Omtata, constitutional imperative, and what Conchella says, administrative. But then you look at the eventual verdict in Conchella, even when they say it's administrative, they set out the preconditions for that. And the question you want to answer is this, my lords: have those preconditions even been met, assuming even that you take it by administrative, for the Deputy Chief Justice to take up the tools of constituting a bench? Because that's a limited question that we are here to address and to guide this court. I make an argument that none of those grounds has been met. For example, we sat in this court in the morning, and I know this question will arise subsequently when we deal with the application for recusal, where my lords say, no, you know, in the virtual courts, in the virtual system, we can sit on anywhere. I'm trying to paraphrase it, my lord, so if I get one word wrong, it's not for any ill intention. We can sit at any time. We can sit from anywhere. We can sit on any day. So that, can the Chief Justice, for example, be virtually absent? Is it possible that the Chief Justice of Kenya distinguishes herself as the first person to be absent virtually? Wherever she is, at home, in Europe, in Asia, in Australia, in Kenya, whatever it is, can she be absent virtually? The answer is an emphatic no. That in the virtual space, it is difficult to justify absence. Is the Chief Justice disabled? At least, it has not been suggested by the applicant, nor the respondent, that the Chief Justice is disabled. And therefore, even looking at the Conchella decision, none of the provisions cited there to justify the link of administrative has been met. In which case, the Deputy Chief Justice has no basis upon which she could have taken up the charges to constitute this bench. In a virtual court, my lords, and we must be very careful about this, because I kept asking myself this morning, I've never been a judge, maybe one day I will be, maybe not, how uncomfortable it would be to sit as a judge when you perceive that some of the parties believe are uncomfortable with you. It must be a very frustrating situation to find oneself in, and my sympathies go out to all judges who find themselves in those circumstances. That's why I'm making this argument. But the interface between litigants at the judiciary in this technology space is the CTS, the e-filing system. There are no directions from the Deputy Chief Justice in the e-filing system that we are interacting with. None whatsoever. Is the judiciary immune from the principle of transparency and accountability? It is not. If the Deputy Chief Justice makes such a consequential move as taking up the powers vested expressly in the Chief Justice, that's a matter she must, number one, expressly disclose by lodging it in the CTS for us to interact with. Number two, provide reasons for taking up that role in that direction. We ought to have seen a decision saying, for the following reasons, I take up this role of the Chief Justice, then proceed to give direction. In the absence of that step, my lord, you have stood up as individual judges, as some of the greatest defenders of our Constitution. That character you have established in the past demands that you look at the Deputy Chief Justice in the eye and say, you may have been well-intentioned. You are. You fell short of the constitutional standard, and therefore, by virtue of Article 2 of the Constitution, what you did was null and void. Our seating, the three of us at this bench, is null and void. We must down our tools at that juncture. Allow me to invite my senior colleagues, senior counsel, to carry forward and finish our arguments. And thank you so much.
I will be very brief, Your Lords, Your Ladyship. The taking of the court file 015 from Kirinyaga Court in the middle of the night was a gross irregularity that impacts on a fair trial. The bringing of that file in the middle of the night from Kerugoya, presumably the Deputy Chief Justice, was another gross irregularity. For the Deputy Chief Justice to have sat in the middle of the night on Friday, the 18th of October, was a gross irregularity. The absence of communication from the Office of the Deputy Chief Justice to the parties in 015 was a gross irregularity. For your lordships and your ladyship to have sat as a court outside the prescribed court days on a Saturday was a gross irregularity. The maxim that justice must not only be done, it must manifestly be seen to be done, is an extension of the right to a fair trial guaranteed in Article 50. This litany of irregularities contaminates the sitting of this bench irredeemably. And I would ask that in respect to Article 50, we do not even go into issues of recusal. Your lordship, your ladyship should, on the basis of those irregularities. Now, there is one I have forgotten. When this honorable bench was hearing our plea for an early date, this honorable bench said the earliest date they had was Thursday of this week. So now, with this litany of irregularities, this honorable bench found time to give a hearing today when they say they are only available. Let justice be seen to be done. The only agency that one is able to trace is that somebody somewhere is in a hurry to vacate the conservatory orders that preserve the substrata of the petition was very weighty in order to swear in somebody somewhere. Yes. You are concerned with the Constitution. And permit me to point out with a lot of respect, my Lord, your leadership. I have gone through these things during the radical surgery, and I doubt that we have seen the last of the radical surgery. And my plea is that you preserve constitutionalism, you preserve the dignity of this court, because the people of Kenya are looking up to the judiciary. Only preserve that.
May it please you, presiding judge and members of your court, we thank you for the opportunity to reply as respondents. Before I do that, I want to thank
to find out whether we are with the foreign retail or not.
Yes, how many people are supporting the application?
In number 15.
Are you parties in this matter?
Yes, we are consolidated. So there's a petitioner, the second petitioner, who was.
For the second petitioner, with the support of the application side, this is Kemoto Teresia Wanjiro from Tess Kemoto and Company Advocates. For the second petitioner. Yes. So perhaps if I'm also allowed to submit or go to. Okay, thank you. So, Your Honor, I'm in support of the application. The fact of the matter and why we are in support of it is, number one, as I said earlier, we were never served with those directions. And the fact that we were never served, this is proper procedure. That's any matter that is taken before a judge. All parties must be notified. We were never notified. So why we were never notified, and I had to learn about this issue today, I do not know. That raises eyebrows. And from the petitioner's side of view is, will this bench be impartial? Or we will be hard? Because if directions are being taken, petition E013 of 2024 is part and parcel. In fact, it was consolidated. We have not been notified. Why? Number two, the issue of fair hearing, Article 50, has been repeated over and over again. Isn't this a violation of the second petitioner's right to fair hearing? In fact, some of these applications, I'm getting them now. Yet, I should have been served before. Why the hurry? Why the rush? Why am I supposed to be served right now in court and I'm told 5 minutes submit? What is in stake? Let us all get a fair hearing. And with these preliminaries that are coming up, one is meant to wonder, will we really get justice? Petition E013 2024 was filed before petition E014 and E015.
Council, just for your information, those were your orders you got from Kegoya, where the petitions were consolidated. So that must have been your application before that court.
Yes.
So don't bring it here.
Yes. But the issue is, even after it was brought here, it is being mentioned and we are not aware. So if a matter is going to be mentioned and we are not aware, then it only shows either the bench is ignoring us or perhaps our petition has no merit, and why so, yet we have not submitted. Let us be given a chance, let us be given audience, even to reply to the issues that are being brought forward. And we cannot reply when standing right now. I need time, I need 1 hour or 30 minutes or whatever, but I need time. So those are the issues why we are in support of this application. We feel that we are not being given a fair hearing. And the other issue that has been raised also, that the bench sat on a Saturday. We are not aware, we are learning right now. We know court operates Mondays to Friday, 8 a.m. to 5 p.m. This Saturday, when was this direction issued? Why were we not informed? So those are the bases why we are now joining hands. Though our petition has its own grounds, but then again, because of those issues, we feel if we don't raise this issue, then we might not get proper justice, because there are some people who, of course, are SDAs who are not able to sit on Saturday, who are not notified again, you know, those kind of issues. That's why we are wondering why the rush. Yes, maybe.
Yeah, on the application for empanelment.
Yes. Yes. That is the issue. The issue was that, and I've also talked about it, we were never informed. And any petition, any case that will be given direction, so long as I'm late, so long as there's a petitioner there, I have to be heard. And that is the law. And there's nothing new I'm saying. This is the procedure all advocates use. Why is it that I'm being ignored? I'm being notified 11 a.m. watching television, and I was very eager like any normal Kenyan. I see my petition being mentioned. I was very angry, but I decided to take a vehicle from Kirinyaga County quickly to come before this court and inform the court that that is not fair. That is not fair, and Article 50 has been violated. And this being a constitutional court, kindly allow us to participate fair. Yes.
Your Lordship, in the limited time that you started, your name please, my name is Rigathi. Within the limited time that we sat with my learned friend, Mrs. Kimova, and despite all those challenges, we have come up with about 4 points, which we request that we be allowed to submit on, since we did not have more time to file documents in support of the application. So kindly, my Lord, give me 5 minutes. Your Lordship, the powers that are given to the Chief Justice to empanel a bench, as submitted by my learned friends, is not a power that can be delegated. In constitutional classes, which we have the privilege to be tutored by Senior Counsel, Professor Gideon Muigai. He told us that there is a principle called delegatus non potest delegare. A delegate cannot delegate. So that the people of Kenya have delegated power to the Chief Justice to exercise that power. And the Constitution does not leave any room for delegation of that power. So now, we are before you, having been empaneled by a person who does not enjoy the people's power to empanel a bench. My Lord, this is a jurisdictional question rather than an administrative question. And from the decisions which have been cited by my learned friends, Kemri, Okiom Tata, and the Conchella case, one thing we learn is that in Kemri and Okiom Tata, the court said this is a constitutional function and it cannot be delegated. When you go to the Conchella case, the court allowed or said that the Deputy Chief Justice could empanel a bench. Again, it went ahead and gave some conditions. I don't want to go through all that. But Your Lordship, what you learn again is that shortly after the Conchella decision was made, an appeal was filed in the Court of Appeal. And who filed the appeal? It is the National Assembly, who is a respondent today. It is the Senate, again, who is a respondent today, urging him to take a contrary position. What was the argument by the National Assembly and the Senate before the Court of Appeal? The argument was the Deputy Chief Justice cannot perform this function. And on the basis of that, kindly stay the proceedings before the High Court. I'm referring to Nairobi Court of Appeal, civil application, number E097 of 2021. So the Senate and the National Assembly went and argued before the Court of Appeal. Don't allow those proceedings to go on before the High Court, because that bench, a 5-judge bench, is appointed by a person who does not have the authority to appoint. And the Court of Appeal considered that application. In the ruling, the court agreed with the National Assembly and the Senate. And the ruling does not have a paragraph numbers, but towards the end, now in finding that the Senate and the National Assembly had an arguable case, they said, as we have observed, an arguable point of appeal is not one that will ultimately succeed. The point intended to be argued, whether the Chief Justice was empowered by the said article, the article we are discussing, to empanel a bench of the High Court, is not an idle one. It's not an idle point. It is an arguable point. The court, on the nugatory aspect, stated that on the nugatory aspect, it appears to us that if it was to be held on appeal, that the Deputy Chief Justice had no power to empanel the bench, the appeal would be a victory with no practical effect and academic exercise. So, the court also considered the third aspect, which was introduced by the Supreme Court in a previous decision, the public interest consideration. And they said, we find also that this is a matter in the public interest domain, and it is proper that the appellant exhaust the appellant's rights. So the court went ahead and said that the motion succeeds and state the proceedings in the High Court, and to date, the state. And the appeal was supposed to be determined in a certain period of time. The appeal is still pending, and the proceedings in the High Court are still state. So, my Lord, you are at the place where the 5-judge bench found itself. It made a determination, it was stayed. So today, we do not have any decision where the empanelment by the Deputy Chief Justice stands. Therefore, before we proceed in these matters, kindly find that the Deputy Chief Justice does not have power to empanel a bench of an even number of judges to be appointed. Thank you very much.
Your Lordship and my lady, within my pleasure, my name is Sakimpa. I act for the third petition in this consolidated petition, which was Kerugoya E014 of 2024. Your Lordship, I want to begin to say that the proceedings that are before this court today are fruits of a prisoner's tree for the following reasons, my Lord. The first reason is that, Your Lordship, our matter was referred to the Honorable Lady Justice, the Chief Justice, on 11th of October 2024 for empanelment of a bench. Your Lordship, the same has never happened until the conservatory orders in petition E015 were granted. It therefore shows, Your Lordship, that petition E014 as consolidated E013 are here to seal the loopholes so that we cannot question why petition E015 was brought before this court before E014. Your Lordship, I just want to agree with all the submissions by my learned friend. That is my submission.
Can I address hearing of matters during night hours. The answer to the respectfully, my Lord, that judges can hear matters at all hours. I have done so. The colonial judges had cases at odd hours in the middle of the night, early hours of the morning. I remember appearing before Chief Justice Simpson that these would be cases with simple matters, like individuals who want to bail at night because probably they've been in the bar, they have drunk a lot, and they want to bail. You rush from the judge's home or the Chief Justice's home, I would grant a bail. It's a beautiful custom, beautiful practice, and I invite you to respectfully, my lords, that you endorse it in your ruling. It gave justice to people. It was a good practice. Instances like in Mombasa, Your Honor, you would have foreigners who have had children, still minors, our local girls, and you want now to fly out with these little children at odd hours. They want to get to work, they want to get to the ships at odd hours, and you rush to a judge at night, and he will give you an order, and you go and stop it. During those days, Your Honor, something that I don't see these days, I wish it could be reinstated. You would have names of the judges in publications, like telephone directories, their telephone numbers would be there. You would know where they live. You would rush to a judge's home because you know where he lives and so on, and he would grant you orders. We no longer have that type of thing at all. I wish it could be reinstated. those helpful in the handed down justice in the court. I recall one judge I appeared before, and I think he had me talking to his askaris at night, and he came out, shouted, "Who is that?" Somebody said, "Oh, it's Khalilma. He wants to come and be heard." And they shouted at me and said, "Khalilma, I want you to know I'm not a judge during the day. I can't hear you, the time is over." And I returned and told him, "Judge, the world will be shocked to hear, or the country will be shocked to hear. You are only a judge during the day, and at night you are not a judge." My Lord, let us reinstate that person, say so very loudly in the ruling. But then, coming to instant case, what has happened is completely wrong. Your Honor, the Deputy Chief Justice, his powers are set out in Articles 147, 148, 149, 150, 151. He has enormous powers. If a person can become a president of the Republic at any time. Your Honor, if you're going to hear his matter regarding impeachment, you should hear it during the day and it should be heard in the parties. It's not a matter that can be heard at all. What the Deputy Chief Justice or whoever it is would have done is to get on phone, to get in touch with the attorney general, get in touch with the advocates, and ask them, "Can you come?" But it should not have had this matter exported. This is not a matter that can be had exported at all. And then also, when you look at the Constitution, and what the Constitution seems very clear. I will refer you to Article 165 of Article 4. 165 of Article 4. If you permit me just to read it to the court. It says that, not 165, Article 144, sub-Article 4, my Lord. Article 144, sub-Article 4. It says that 144, sub-Article 4. So sorry. Yeah, if you look at that 144 of Article 4, 144. Yeah, thank you very much. If the Chief Justice is unable to appoint a tribunal under Clause 3, the Deputy Chief Justice shall appoint such a tribunal. So you see very clearly, Your Honor, where the Deputy Chief Justice can act, it is set out in the Constitution very clearly. Now, in this particular case, it is not set out in the Constitution regarding impeachment. It does not confer power on the Deputy Chief Justice at all. If I may also refer Your Lordship to impeachment provisions relating to the Deputy Chief Justice, Article 144, Article 145, Article 150, Article 1B. Those provisions are expressed. Now, the next thing I may wish to deal with is, if you could look at Article 165, Article 4, 165, Article 4. 165, Article 4. It says that any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned to the Chief Justice. Now, before the Chief Justice appoints the Chief Judges, he takes into account a number of things, my Lord. He takes into account the experience of the judge that he is appointing. take into account things like whether it would probably bring a conflict of interest. It would take into account whether there would be objections from certain individuals and so on, but not to do that at all. It takes into account a lot of things. It's not just an exercise where he writes down the names of judges immediately. He takes into account a lot of things before he appoints the one and so on. Now, in this particular case, Your Honor, this may not have, it's not powers that can be delegated to the Chief Justice at all. It is specifically and expressly delegated to the Chief Justice. Now, with the new technology we have, the Chief Justice happens to be out of the country. There's nothing that stops an individual or the registrar from getting in touch with him and explaining to her that, look, we have got this matter coming up. There is the issue of appointing 3 judges to here. Can you have your views? And they would probably say that, look, why don't you have so and so, so and so, so and so, so and so, and you would actually assign the judges to hear such matters. I would emphasize, and I also keep myself with my other friends, that there has to be miscarriage of justice. The Deputy Chief Justice should not have done what he did at home. Not that you have got anything against her. Not that you are alleging that there is something that she did which is not, she should not have done. There is also the issue, Your Honor, when you're dealing with matters of this kind involved, the issue of perception. Perception is important. When a Chief Justice performing, a Deputy Chief Justice performing such a kind of job or exercising such a power, what perception are other people calling together? They may read a lot into what she has done. It may be correct or it may not be correct, but there it is. They may come to a conclusion that, look, the Deputy Chief Justice probably is acting under direction of the executive, under direction of the President. That may not have been done, but that is a possible perception. It sends the wrong perception to people. And when you are giving matters to do with the administration of justice, perception is important. What signals are you sending out? And in this particular case, a matter involving the Deputy President of the country is being removed under suspicious circumstances. Is it wrong people to suspect that the Deputy Chief Justice was probably preferred instead of the Chief Justice? Is it wrong people to probably to the chain when they're having their first kind of dealings that the Deputy Chief Justice is possible that the Deputy Chief Justice is taken because he's a friend of the executive and such things and so on. So to make sure that we do not have such allegations, we stick to the law. We stick to the Constitution. So I emphasize before I sit down that what has happened is wrong, must be condemned, and we should uphold the submissions of my able-learned friends. There is a word somewhere, I think in the Constitution, that the Deputy Chief Justice may perform functions today or the duties of the Chief Justice in absence. Clearly, that refers to cases where the Chief Justice may be relieved or the Chief Justice may be sick or the Chief Justice may be involved in something that is cannot enable to perform the work and so on. Now, in this particular case, nobody has alleged to the Chief Justice for anywhere. Nobody has alleged to the Chief Justice on duty, and nobody was alleged anything that made it impossible for the Chief Justice to carry out her duties at all. Again, I emphasize the question down on removal of the Deputy President has talked about. And it's something that is making a number of Kenyans entertain us of interesting things and so on. Yesterday, I think it was on Sunday, was when I was sitting in my house, I decided to listen to the word of God on TV, and I sit down. I decided to listen to the word of God from a lady preacher, and she was saying that what is going on now? God no longer has any confidence in the current account. Now, you can't blame us when such things were happening. You can't blame us and come to the conclusion that the Almighty God and Lord Jesus Christ no longer support the current government because of such things. I argue respectfully that you have full submission of my own friend, Mr. Kigwe, and his care colleagues. They are ever sufficient, and it is thank you.
May it please the court, we will try on the side of the respondents to be precise and concise. Let me start off by thanking Dr. Ogada and Mr. Ongoya for their very kind remarks about the small role I have played in the development of our constitution and law. Thank you very much. I also want to thank Council for the civility that has been observed in the presentation of this matter, and I do hope that the respondents will also remain civil so that we extend the proper respect that the court deserves. I am instructed by the Honorable the Attorney General, a very eminent Dorcas Oduor, our first female Attorney General, and she instructs me to inform the court that she is here because Article 156, sub-Article 6, enjoins the Attorney General to promote, protect, and uphold the rule of law and to defend the public interest. The people of Kenya have a public interest in the maintenance of a stable government and in the protection of the sovereignty of their republic. And that republic is underpinned by having continuity in the institutions of government, be they the legislature, be it the judiciary, or be it the executive. We shall be submitting that the public interest is in favor of an expeditious disposal of matters that affect the continuity of government and that imperil the stability of the state. And that human rights are not only accorded to individual applicants, they are also accorded to the collectivity called Kenya. And the people of Kenya, they also have human rights. I agree with my learned friend, Mr. Ongoya, who is a very eminent constitutional jurist and a practitioner of the constitutional law. I agree with him when he says The Constitution 2010, in many ways, is transformative, has introduced more versatility in the protection of human rights. That is true. I also agree with him when he says that the Constitution must be construed in a manner to give full effect and protection to the rule of law and to human rights. But I further submit this, that the Constitution too must be interpreted so as not to create an absurdity. The Constitution must be construed so as not to create an absurdity or to put it in conflict with itself. What is the purpose of the Constitution? To establish the state. What is its further purpose? To provide for democratic government and to protect the rule of law and to protect human rights. These are not in contradistinction. These are not at war with each other. A stable government, a sovereign people, and human rights are not in conflict with each other. They are in harmony. It is the work of the court to interpret in order to create that harmony. When the court is invited to interpret the Constitution so as to create an absurdity, it must refuse to do so. This afternoon, you are being invited to interpret the Constitution to create an absurdity. Why is it an absurdity? The Deputy Chief Justice of the Republic of Kenya can swear in the President of the Republic of Kenya into office. What a huge power, what a huge authority. The Deputy Chief Justice of the Republic of Kenya can empanel a panel of judges, can appoint a tribunal to remove the president from office. What a huge responsibility. What huge authority. But wait a minute. The Deputy Chief Justice cannot assign duties to judges. Pray my lords. What then does the Deputy Chief Justice deputize? What does she deputize? In many jurisdictions, like those referred to by the distinguished counsel on the other side, in many jurisdictions, including the United States, there is no office of Deputy Chief Justice. In the Supreme Court of the United States, there is the Chief Justice and Associate Justices. In Kenya, the drafters of our Constitution, and if I may say so myself with a bit of humility, I was one of the drafters. Knowing that in other countries there was no office of Deputy Chief Justice, decided in Kenya there shall be an office of Chief Justice to deputize the Chief Justice. In doing what? I'll be very brief. That is to be found in the Constitution itself and in the statute. And I think I will leave my learned friend, Mr. Gobo, to deal with that. But let me, in the 2 minutes I've been granted by this gracious lady, make 1 point, 2 points. Beneficiaries of ex parte orders stand before this court and say only they are entitled to ex parte orders. They are here to complain that they went before Judge Gongo, they went before Judge Mwita, they got ex parte orders with finality, and that was okay. But when the Attorney General went ex parte, and all her prayers were refused, except the prayer to send the matter to the Chief Justice, she was wrong. How is that possible? My lords, I want you to remember, because it is in your file, the transmission from Kiriboya is in the portal. Unless my learned friends are saying they have never seen the portal itself. Yeah? The registrar in Kirinyaga, Honorable Wanyama, writes a letter, yes, saying, good evening, kindly find attached the document for your attention. It has a time to the Chief Justice. It is on the 18th, and it is 15:45. It is 3:45 in the afternoon. So when council repeats again and again, things were done at night. Well, a lie can go halfway around the world before truth wears its pants. It is not true. It is not true. The registrar sends the order at 3:45 in the afternoon. I stop there so that my learned friend will continue.
Thank you. My lords, I will take it up from there, and I will dive right into the constitutional questions. The application before you for challenging the panelment of this bench addresses itself, my lords, to the powers of the Chief Justice under Article 161, 2A and B, that establishes the office of the Chief Justice as head of the judiciary and of the Deputy Chief Justice as the deputy head of the judiciary, and conversely, my lords, to Articles 163, 1B, that again provides that the Deputy Chief Justice shall deputize the Chief Justice and be the Vice President of the Supreme Court. My lords and your ladyship, it is now beyond our adventure, and again quoting from the CTS, that while council submitted that there may be instances of delegation, they ignored, my lords and your ladyship, that the law expressly provides instances or gives direction as to when the Deputy Chief Justice shall exercise the powers of the Chief Justice. And my lords, this is expressly set out at Section 5, subsection 2A of the Judicial Service Act, Chapter 185B of the Laws of Kenya. The Judicial Service Act expressly provides, my lord, that the Chief Justice can deputize, or the Deputy Chief Justice will exercise the powers of the Chief Justice in the absence of the Chief Justice. And lords, the CTS and my friend Professor Gilmugai referred to this. There are only two professors, senior counsels here, so it must be correct. My lord, in the CTS, it is clear that the Chief Justice communicated to the Deputy Chief Justice that should be a way to Geneva, Switzerland, and Milan, Italy, between the 12th of October 2024 and 24th of October 2024. That is it's in the banner. It's on record. It's on record. Senior counsel and my pupil master coordinated.
Keep your voice calm. Keep your voice calm. There's no need to shout. I was asking the court whether this material is part of the contract.
It is.
Or whether it is.
That's why you taught me to submit
politely.
You taught me to submit clearly, and I'm polite. Yes, I was speaking. Lords and your leadership. It is
Your Lordship, it
therefore
is important that in my address to the court, I indicated that the respondents in that application did not file any replying affidavit, through which this material could then be introduced before you.
My Lord, it is part of the record. The record.
The material which is in the court portal is part of court record.
Your Lordship.
If it is not on the portal, it's okay. If the material is in court portal, it's part of the court record.
Your Lordship, there's
Mr. Ndegwa,
Just for good order, my lord, that we make progress. Then we know, because we access the portal through particular case numbers. In which case file is this material available, so we can just log in and get to it.
My Lord, it is not in my place. You start educating, demonstrating my and friends what files to do. Because this is the portal. I would have had no other way of accessing.
Professor, can you just give us a reference?
Yes,
for purposes of clarity?
Yes, my Lord, 05, we have 3 cases that are consolidated. We have accessed the portal in E015 of 2024. A transmission from Claire Wanyama, and E014 as consolidated. We have this material, we are aware of it. We have even gone further, my Lord, and served or passed on the communication to my land. It is in the public domain, my Lord. We could not have secured this communication anywhere else.
Sorry, do you mean to say that what you're holding is filed on CTS?
It is.
Does it have a date and time?
It is in the. What I have here is a copy from the CTS, the reference of the Chief Justice Office. We only accessed it from the portal.
We are straightforward. There's an internal memo we've just been given here. My colleagues are saying it's on the portal. If we knew the case number which it was, we would have verified it. The other option would have been for my colleagues who are making a particular application this afternoon, have they filed an affidavit running this document? Truth of the matter is that documents in the CTS have a timestamp, as my lady points out. The document we are having here does not have a similar timestamp. We're just saying, show us where it is so that we authenticate, then we make progress. It doesn't make sense to demean the rest of us when you're asked to authenticate. You do precisely that, you authenticate.
But Lord, I can confirm that it is even the physical file. The document, the physical file. So that my learned friends do not have it, or that they are shocked that the Chief Justice is not in the country, should be a point for response. They can respond and say, we saw the Chief Justice around. That's a process with them. My Lord, if I may raise my time, they will have time to respond. Yes, the judicial portal. I can proceed.
My lady, I have a specific question. We want to know in which case file in the portal, because that's the submission my colleague has made, there's this internal memo. First, I want to know the internal memos are normally in the portal. I'll be glad to learn. But more importantly, in which case file is this internal memo so that we can authenticate. That's simple. My colleague who said it is in the portal. He has a duty to furnish us with the particulars.
We have indicated, my lords, that it is in the physical file. My life friend is in the module specifically addressing them so that I can proceed.
Your Lordship, would you kindly give us a ruling on our objection?
Please, the applicants, when you are submitting, the respondents gave you time. Please just give them time to make their submissions. You are going to respond. There will be time for you to make a recommendation.
My lord, the proceedings before you are in the public interest. They are in the public interest, and therefore the question of time management, my lords, and the need for expeditious disposal of the application before you cannot be overstated. My lords and your lordships, time and again, my friends have submitted that whereas this court can sit at odd hours where it receives an application, that in matters as mundane as the current matter before you, that this court should have had this matter in the course of the day. Because No doubt, my lord, this court has moved to the electronic age where matters are transmitted through mail and through other forms. My lord, but most fundamentally, we are here to challenge ex parte orders, not inter parte orders, not orders given inter partes. And my learned friends therefore cannot speak from both sides of the mouth that where you are dealing with matters of the impeachment of the deputy president, such as this, that ex parte orders cannot be issued, yet they obtained ex parte orders that necessitated the filing of the application before you. My lord, what we're dealing with here is a removal under Article 145, and which the law defines as final under Article 145(7) of the Constitution. When therefore my learned friends submit about the office of the Deputy President, they seem to forget that Article 145(7) refers to the finality of the Act of Senate. And therefore, all the orders obtained under the subject, all the orders obtained under the subject of this proceeding were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly, so that this court can move to the next phase. And the next phase, my lord, would be dealing with the question of the next step. My lords and lordships, it is clear that my learned friends do not want to proceed with that phase. And that is, we have all these multiple applications and the inability of the applicants to want to be confined to the question of time. They want to speak throughout the night. On our part, we want to sanitize this proceeding, my lord, and stick to the point that the application does not meet the threshold set out for recusal, because recusal is also a prayer. They have advanced no reason at all to want this court to recuse themselves or to find that it was not empaneled in line with Article 161, 163, 52A of the Judicial Act. We opine, my lords, that this bench was properly constituted by the Deputy Chief Justice, exercising powers donated to her by the Chief Justice, unless they're saying that there's another Chief Justice. Thank you.
My lord, my ladies, as a follow-on to the submission by my two learned senior colleagues, I wish to respond further to the application as follows. There has been a lot of water under the bridge since we convened, or since this court convened at about 11:15 or 11:30 this morning. But as I am no doubt members of the court will be able to quickly figure out, the single issue that is before you is a challenge as to the regularity of this, of the referral of the 3 or 4 matters to this bench by the Honorable the Deputy Chief Justice, the Deputy Chief Justice of the Republic of Kenya. And I wish to commence my response to that objection by saying as follows. The Chief Justice occupies 3 distinct constitutional offices. 3 separate and distinct constitutional offices. First, the Chief Justice, by dint of Article 161, Sub-Article 2A of the Constitution of this Republic, is the head of the judiciary. By dint of Article 163(1), the Chief Justice is the President of the Supreme Court. And by dint of Article 248, Sub-Article 2E, the Chief Justice is the chairperson of a constitutional commission established under Chapter 15 called the Judicial Service Commission. Members of the court, I wish to take just a moment to demonstrate how the Chief Justice is deputized in these three distinct constitutional laws. In respect of her capacity as the President of the Supreme Court, Article 163, Subarticle 1B is clear that the Chief Justice shall be the President of the Supreme Court, A, and that B, the Deputy Chief Justice shall deputize for the Chief Justice and shall be the Vice President of the Court. That is the first constitutional office. The second constitutional office is the head of the judiciary, and I will come back to Article 161 in a moment. Suffice it to say that it is in Article 161, Subarticle 2, that the office of the Chief Justice is established. And Article 161, Subarticle 2 states as follows: there is established the office of the Chief Justice, who shall be the head of the judiciary. I will come back substantively to 2B in a moment. But it is important that for the purposes of the commission established under Article 248, Subarticle 2E, the Deputy Chief Justice is then not the Vice Chairperson of that commission. In the Judicial Service Commission, the DCJ does not deputize the Chief Justice. Now, it is our position for the respondents that Subarticle 2A. That is not the President of the Supreme Court. That is not the chairperson of the Judicial Service Commission. But that function is exercised by the Chief Justice in her capacity as the head of the judiciary. It is our submission that therefore the Deputy Chief Justice, who is the Deputy Head of the Judiciary, by dint of Article 161, Subarticle 2B, can exercise the function of the Chief Justice as Deputy Head of the Judiciary. And members of the court, Article 161, Subarticle 2 creates three positions: the Chief Justice, the Deputy Chief Justice, and at Subarticle C, it creates the office of the Chief Registrar of the Judiciary. Now, the Chief Registrar of the Judiciary doesn't deputize the Deputy Chief Justice, but the Deputy Chief Justice deputizes the Chief Justice. That does not require any interpretation. That is really comprehension as a matter of English. It is then for the Deputy Chief Justice, in instances where the Chief Justice is unable to act as the head of the judiciary, the Deputy Chief Justice can then perform that function. Members of the court, I submit that the decision in Lina Conchela is good law. And the facts in Lina Conchela are important. When you retire to consider your decision in this matter, you will note that the only respondent in Lina Conchela was the Chief Justice. The only respondent in Lina Conchela was the Chief Justice. If for the sake of argument, we go along with the submissions made by our learned colleagues for the applicants this evening, that the Deputy Chief Justice then cannot deputize for the Chief Justice, then in Lina Conchela, when a judge of the High Court certified that the issue in that matter was one fit and proper for an expanded bench under Article 165.4, then going by the argument, then there would be nobody to empanel the bench because the Chief Justice was a party. How can he or she empanel a bench in a party where there are respondents? That is the absurdity in the argument by the other side. And my lord, it is our submission, or it is our position, that the constitution of this republic must remain elegant and it must remain functional. Interpretations such as the one urged by my learned colleagues for the applicants that would lead to that sort of an absurdity should be rejected by the court. It is my position, as I am on my feet this evening, as I have been consistent, that the Constitution says what it says. But the Constitution only means what the courts of law in the Republic of Kenya interpret it to mean. And it is the interpretation of the Constitution that gives it life, that gives it meaning. And my lord, my lady, it is therefore my submission that it is a proper interpretation of the Constitution, flowing from the express provisions of Article 161, subarticle no doubt that as you sit as the three judges presiding over this matter this evening, you have no doubt as to the regularity of your environment. Because if you did, and flowing from the accolades that have been heaped upon you by learned counsel for the applicant, then you would not touch this file. There are other files that are equally urgent, that deal with the same issue, that have been brought to your attention this morning, this afternoon, and maybe again this evening, where you have said, in the absence of that direction, under Article 165, subarticle 4, you are unable to deal with those matters. So, my lord, my ladies, being satisfied, or you being satisfied with the regularity of your empanelment, this application is for dismissal. And I must add, with cost, so that the important substance in this matter can be determined by the court. I'm most of that.
My lords, my ladies, permit me to just conclude with giving a bit of a context in the Conchella matter. I'm not going to explaining anything because, my lords and my ladies, the decision speaks for itself. The decision is a decision of 5 judges of the High Court. In particular, my lords and my ladies, paragraph 97 is instructive. 97B in particular, if I may, reads that the exercise of powers under Article 165(4) of the Constitution, though constitutionally underpinned, is administrative in nature. They go on to add that being administrative in nature, the said mandate can be exercised by the Deputy Chief Justice when the Chief Justice is absent, when necessary, or if for good reason the Chief Justice is unable to exercise the mandate. At D, they conclude that in the present circumstances, the rule against bias and the rule that no person shall be adjudged in their own cause dictates that the Chief Justice, being the main respondent in the instance petition, could not assign judges to hear the petition. My lords and my ladies, that is the absurdity that learned senior counsel, Professor Gidu Wigai, was talking about. Take it a step further. Is it therefore their case that if, as contemplated by your lord, their lordships in that matter, if for one reason or the other, the Honorable Chief Justice is unable to perform the functions of that office, is it therefore their case that no matter that requires constitution of a bench will be heard or determined? That certainly would be an absurdity that the law would not have contemplated. That said, my lords and my lady, one of the things that will play out by close of business these submissions is that our learned friends from the other side have very deliberately taken to concealing what would otherwise be material information before this court. I say that for two primary reasons. I want my lords and my lady to make reference to their own application, to the grounds supporting the application. They start, the application is based on the affidavit of Honorable David Muja Matenge and other grounds. The other grounds include A, that on the 18th of October 2024, the petitioners herein filed the instant petition together with an application under certificate of agency seeking conservatory orders restraining the assumption of office by the second interested party pending the hearing and determination of the application and petition. They go on to say that on the same day, the matter was placed before the Honorable Justice Mwongo, who considered the matter, and in light of the urgency of the matter and the weighty constitutional issues raised, the Honorable Judge issued the conservatory orders sought in the first instance and certified the matter as raising weighty constitutional issues and referred the matter to the Honorable Chief Justice to constitute a bench to hear and determine the petition. This is where now the story starts. That on the next day, being Saturday 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with the order of this Honorable Bench stating that the first and second respondents' applications dated the 18th October 2024, in bracket the applications for were to be had for their inter-parties hearing on the 22nd of 2024. Why do I say there is deliberate concealment of material facts? It is because, my lords, looking at the files that were coming up before this court today, that is E565 of 2024, before the court in Nairobi, and E015 of 2024 in Kerugoya. We immediately, upon learning of the orders that had been issued and which have been adverted to here, filed an application. It is on record. That application, my lords and my lady, sought several prayers. One was that we wanted to have that application certified urgent. Like in their case, our application was certified urgent. Again, we asked that the court considers hearing the application outside the normal court hours, including a possibility of being heard on a Saturday. My lords and my ladies, that prayer was not granted. We also, as a third limb of our application, asked that the court considers granting an ex parte order staying the decision of the Honorable Justice Mwongo and the Honorable